This is case number 19-240893. This is Starlene Bragg versus Ardina Hendrick. The matter is before the commission to reopen the matter after closing, after the matter was closed based upon the bankruptcy filing. Your appearance, or do I have Starlene Bragg on the Zoom, please?
Yes.
All right, good morning to you, ma'am.
Good morning.
Looking now for Ardina Hendricks. Do I have Ms. Hendricks on the Zoom? Ardina Hendricks. All right.
She was on here.
She was just on there.
All right, so let's give her a moment to see if she's going to come back in. I'll come right back to you, Madam Bragg. All right, the court's going to call case number 20156-170. This is Crown Asset Management LLC versus Kewana Fair. The matter is before the court, set on for a review. That's your appearance for Crown Asset, please.
Good morning, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P61828, appearing on behalf of the plaintiff. Thank you.
Thank you, Mr. Canine. Good morning to you. I'm looking now for Ms. Fair, please. If you're here, say something at this time. I'm looking for Kewana. It appears to be Fair. If you're here, please say something at this time. Wave at me if you're not able to say something. All right, counsel, have you spoken with Ms. Fair today or at any time recently, sir?
I have not, and she is making monthly payments, I think pursuant to a garnishment. But no, Your Honor, to answer your question, I have not spoken with her recently.
All right.
Is this her, Judge? Because where's his iPhone 5? The lady saying something.
All right.
Yes, I think that's her, Judge.
All right. If that's you, ma'am, all you need to do is hit *6 on your device and that will unmute you. *6 on your device, please. All you gotta do is hit *6 on your device and that will unmute your device.
Oh, okay. All right. Hello?
All right, who are you, ma'am?
Hello?
Oh, what's your name?
I'm here.
What's your name?
Oh, this is Kajana Fair.
All right, thank you, Ms. Fair. Good morning to you, ma'am. I have your case set for review this morning, and the attorney on the other side is here. He's indicated to me that you've been paying through some type of garnishment on this case. So I want to find out a little bit more. I want to find out a little bit more information about this. Mr. Canine, I see that this was a judgment that looks like it was about $800, a little over $800. How much money is owed on this?
Much, Your Honor. She only owes another $200.
200. Just one moment, ma'am.
207.
Okay.
So another payment, as though she's been making actually less, will satisfy the judgment.
All right, so Ms. Fair, it seems like you've been paying under a garnishment, and one additional payment would close this case out. So it's about just over $200 that's owed. That last payment would be the final payment on this case. You understand that?
Yes, I understand that. I was shocked to get a hearing because I had sent a letter when I got the papers, but it was too late, and so they started taking money out of my check. So I was really hoping to hear that this check would be the last time they would take money out of my check.
And that would be correct. This next payment, whatever that garnishment is, that should be the last one, ma'am. That should satisfy it, and then you shouldn't get any more garnishment. You understand?
Yeah, I understand.
All right. All right. With that in mind, I'm going to I'm going to go ahead and close out the hearing on this case, knowing that there will be a satisfaction of this case with that final garnishment, and that should be the end of this matter. All right. So I wish both
Okay.
sides. All right. I wish you well. Do have a good day now.
Likewise,
Thank
thank you.
you.
Take care.
Good day. Did Ms. Hendricks come back in yet? Ms. Hendricks, I'm looking for you. If you're there, ma'am, say something.
Yes, I'm here, sir.
All right. So I'm on the record in 0893 Bragg versus Hendrick. This matter was closed due to a bankruptcy filing. Apparently, that bankruptcy has since been dismissed, and so there's a petition to reopen this matter. And Ms. Hendrick, is it in fact true that your bankruptcy petition was dismissed, ma'am?
Yes, sir, it was. But I also, I have a new attorney now, and I have another bankruptcy case, and I have the number here for you.
And when did you start the new bankruptcy case, ma'am?
That case was started May the 10th.
You said May the 5th?
May the 10th.
May the 10th. All right. And did you list this particular case on that bankruptcy petition, ma'am?
Yes, sir, I sure did.
What's the bankruptcy case number that you have? The new number, ma'am?
It's 22-43832.
And what did you file? Chapter 7?
Yes, sir.
All right. That's what it looks like. All right. Ms. Bragg, that would, the filing of an additional bankruptcy would give reason for a stay in this matter, ma'am. And given the case number and the nature of the case that was filed, that would act as a stay in this matter. All right. So,
Can I ask you a question?
yeah, sure.
Is there any way that you can confirm that bankruptcy?
Well, there are probably a couple of ways to do that. What I'm going to do is I'm going to set it over for a couple of weeks, and I'll await the document that is a stay document that will be submitted by the lawyer on the other side. And if I receive that stay document, then that hearing will be canceled. If I don't receive it, then that hearing date will be a date in front of me. So my clerk's going to give us that date in just a moment. But given the case number that I received, that sounds like a bankruptcy case number. And if it's a chapter 7, it's seeking a different type of discharge than the chapter 13.
June 15th.
June 15, 2022 is the earliest date that I can give on this matter. I'll review it at that time to make sure that there is in fact a stay. That's going to be at 9:45 a.m. June 15, 9:45 a.m. That's the next time I'll take a look at this case. Again, if it's a bankruptcy, the reason that for the party's information, the reason you see the court react the way that it does is because, I mean, it's not too much more that's powerful than than if there's a bankruptcy petition, because it stops everything here. This court, you know, I almost have it causes me to have a choke on my words. I don't really have anything to say if there's a bankruptcy petition, because that bankruptcy petition overrides anything that may be going on in this court. That's a challenge. So I am setting it for a review date just to make sure that petition is in fact moving forward. And if it is, of course, it stays everything.
Okay, I had another question if I could.
Go ahead, Ms. Bragg.
Okay, shouldn't that document already been presented before our court date today?
Maybe so. Maybe so. If you want to go, I mean, I feel you, but if you want to go back and forth about that, there's not a whole lot that can be done with that. If she's defrauding the court about a bankruptcy, I'll know that by the 15th of June. It's, you know, it is what it is. I mean, if it was something else filed that I went to my bank and my bank told me to get an adjournment. I don't know, that means nothing. But that bankruptcy petition means everything. That's the challenge. And I don't want to go back and forth and on about it. I set a date to try to control some of that, but the bankruptcy petition is everything. And
Okay.
if I don't get that, then of course, the case is open. If the case is open, then you go forward on, I believe you already have a judgment, go forward on the judgment that you have. In fact,
Yes.
you don't even have to. If the bankruptcy petition is dismissed or anything, you don't even have to come back to this court. If it's dismissed, that means this is automatically open. In which case you would have the right to begin to execute on your judgment, meaning that you can file against bank accounts, you can file a garnishment against employment, et cetera, et cetera, et cetera. You can automatically do it if the petition for bankruptcy is dismissed. So your case is already adjudicated here. It's already over with. You have a judgment. So you can go forward on the judgment if there's no bankruptcy. If there's a bankruptcy, that ties the hands of General Motors Corporation, Apple Corporation, Judge Donald Coleman, Miss Charlene Bragg. That bankruptcy petition tie everybody hands. All right. All right. I wish you well, man, both of you. And hopefully you get this worked out at some point. But as long as the specter of bankruptcy is over this, then that just kind of stops everything. You know, and the law allows individuals to seek bankruptcy protection. And as long as there's a petition pending, then it will stop you from being able to execute on the judgment.
Okay.
All right. I wish you well.
All right.
All right. Thank you.
Okay, Your Honor, can you give me that date again, please?
Yeah, that's the 16th of June.
50.
Let's strike that, the 15th of June, June 15th, 9:45 a.m. You will get something in the mail in that regard.
Okay, thank you.
All right, thank you. Good day to both of you. All
Okay,
right,
Thank you. All right.
The court now calls case number 21. It looks like that case has been resolved. That is 21-152-086. That is Diversified versus Anthony Wiley. I do have indication that case has in fact been resolved.
No, not that. That's for Mr. City of Detroit.
I have this scratched out.
It should be, yeah, sorry, it should be City of
Okay,
Detroit.
got it. Okay,
That's my property.
Okay, my apologies. On the Diversified Members Credit Union versus Anthony Wiley III, a matter is before the court on the filing of a motion for summary disposition. Today is the time set for hearing in that regard. Your appearance at this time for the plaintiff for Diversified, please.
Good morning, Your Honor. Wesley on behalf of Diversified Members Credit Union, P number 80307.
All right, thank you, Mr. Neal. Good morning to you, sir. Do I have Mr. Wiley on this Zoom at this time? Say something if you're here, sir.
Yes, Mr. Wiley's on here, sir.
All right, thank you, Mr. Wiley. Good morning to you as well, sir. I'm looking, I see a quotation regarding a motion for summary disposition. Unfortunately, I'm not seeing the motion in the court's file. So counsel, how long ago did you submit your motion?
This was quite some time ago, Your Honor. This was November of last year.
Wow. I also see in this file a consent judgment awaiting the order via email. Give me some history on this. What happened here? Mr. Neal, and then I'll hear from Mr. Wiley.
We did previously appear, Your Honor. We had come to terms on a consent judgment. The defendant never returned a signed copy to my office, which is the reason for us remotioning this motion for summary disposition. If he would like to agree to the terms on the record and I could submit the order under 7-day, I'd be happy to do that. I'm not sure what we would do with the motion for summary disposition not being in the court's file, but at this time, we're trying to bring this case to a close.
All right, gotcha. So, Mr. Wiley, there was some discussion. I have a notation that it looks like you all had reached a consent and that you were supposed to send back some document that was submitted to you. What's going on, Mr. Wiley?
Okay, so I'm going through like separation and divorce from my wife, and I didn't get that mail till like real late. And I think I talked to that lawyer and I told him that I was having these problems, but I guess I don't know what's done. nobody understand what I have to deal with that. So when I got them letters, they were late. You know what I'm saying? So it's not like I didn't care. You feel me?
Yeah.
So it's just like I ain't even in that house, but my mail go to that house. So I have to go there and get my mail, and I guess she held that up, whatever she was doing. So I didn't receive it. So when I did receive it, it was too late. One thing I could do about it.
All right, so is it, I mean, I guess the key thing here is whether or not you still are interested and willing to go forward with the agreement. Is that something that you yet want to do, the agreement that you reached?
Well, what I want to do is I'm back. I'll be back to work in like probably about 3 weeks. I can go orientation and probably set up a pay arrangement to go ahead and take care of that. Because that's what I can do right now. There's nothing else I really can't do. I'm really in a rock and a hard place. Things are real bad for me right now because of what I'm going through, and this lady is really putting a death on my life, and it's crazy, but life goes on. You know what I'm saying? So I don't want no problems. You know, I really want myself to be clear, but it's just what it is. What it is.
Gotcha. Yeah, I'm sure. I've never been through divorce, but I've represented a lot of people some years ago, and that's tough. Any kids involved?
Yeah, I got one. She wants child support for, but it just I took care of all my kids, so I really don't understand it. It's she mad, so I don't know. It's just crazy. It's just like it's really driving me up the wall. Really, really driving me up the wall.
Gotcha, sir. Gotcha. You got to hang in there. All right, Mr. Neal. It sounds like Mr. Wiley is saying that he's still in agreement with the judgment. He wants a different start date, I suppose, on the payments, because in the agreement apparently he has some payments that he do. Mr. Neal.
So, Your Honor, previously we did not have any payment terms on it. There was a provision to withhold collections for 30 days. I'm happy to allow that from today. I think the date we had to begin for a financial review was April 15th. I'd be happy to push that out to June 15th, keeping all the other terms the same. Just looking for a financial review to set up payment arrangements at a later date, but obviously a judgment holding that the defendant agrees that he does owe the $15,418.97 in damages, $257 in court costs, 75 statutory attorney's fees, with interest running at 10.99.
Okay, I don't want to agree to that, and for fact, she's paying a garnishment that y'all already got for that, so I'm not gonna pay on to what she's already paying. The car, I do the car. She's paying the garnishment for the other stuff because that loan was took out for her. I'm not gonna pay on to what she's already paying on to. I don't deal with that lady, so I'm not finna help her pay nothing because I paid that loan before she started it. You know what I'm saying? The car, we can do that. We can take care of the car, but the other stuff she's already paying. You got record of that. She's already paying y'all.
All right, let me stop you for a moment. The question here, Mr. Wiley, is what you agreed to, number one. And then the second thing, let me just put this out there. I can tell that you kind of want to get this over with and move on with your life. The challenge here is what you signed in regard to a third party for. So if you entered into some agreement, like a joint agreement or whatever it was, if you signed on that credit, then it makes you responsible. Now, they can't collect twice, but it makes you equally responsible for the credit as she would be.
But she's already paying. She did knock it down like $3-4 grand. Almost. She's paying that currently every week.
Yeah. And whatever.
And I get that.
Yeah, and whatever amounts she pays, and indeed whatever amount you pay on this, you're entitled to, once this is paid off, it's paid off. I mean, they don't have the right to collect twice what it's.
But you're right, Your Honor, you're right. But she's not on the car loan at all. That's solely me.
Oh, okay.
Car loan is solely me. Right. I would take responsibility for the car loan. Now I'm understanding what you're saying about the other stuff, but she's more than happily willing to pay that whole other loan off on her own. Besides causing my life a living hell. But she agreed to pay that. She said she don't need no help with that. She'll take care of it on her own.
All right.
Because that
so now,
right.
What you got to do is you got to resolve that has your name in it with Diversified. So the question here is whether or not you will enter into the agreement that was previously entered into, and then beginning in June, take a review as to what you can pay. to start knocking this down, noting also that if she's paying something that affects this particular debt, that would be beneficial to you as well, because when the debt is paid down, it means you owe less and less and less. You understand that?
Yeah, I totally understand that. And from now on here, because I'm understanding it more, I agreed to the car loan because if I ain't mistaken, I think they lost some type of paperwork, and I agreed to that on that term, regardless, because I don't know if they had original documents, they didn't have that document for the car, and I solely agreed to the car because I wasn't really understanding what before. Now that I hear you saying it, now I understand the whole thing now. But that's due to what I'm going through, so don't take that personally. I'm just, it's just everything is messing my head up, you know. And that lady is really a pain. But
Okay,
I
here's the key question now. I'm going to ask that Mr. Neal submit that document to me based upon the agreement that you all reached. That document is going to say that the indebtedness here is in excess of $15,000, and it's going to say that there will be no issue regarding payment until sometime in June. Then the parties get together to try to figure out exactly what a monthly or some type of payment would be on that document. But it will allow for entry of judgment at this point, and then you'll discuss payment sometime beginning in June.
okay, and then my part is the interest part, and she's already paying, so I'm trying to figure out the accumulated of the interest from that he wants, because she's already paying. So I'm trying to figure out what interest does he want, because she's paying that currently right now. As far as that loan.
Mr. Neal, anything on this issue, sir?
Your Honor, given that there is another file, obviously I can't speak to specifics on that file or what any payment terms may or may not exist. I can say that so far against collection credit as to what Mr. Wiley would owe, there's $3,823.77, which has been collected against the file. Interest is running on whatever balance that we would apply to him finally be, because that's per the loan agreement. So obviously you can pay that off early, or, you know, maybe come to a lump sum settlement agreement to forego that interest, but we would ask that the interest continue to run until it's satisfied.
You understand all that, Mr. Wiley?
I understand that. I'm not understanding the interest part, and she's paying like the interest, because I did it, and I do have a question. I'm not trying to get away from the case, but I have a question about the interest. I did get hit with $3,000.
Okay, yeah. Let me stop you for a moment. I think that you probably reached some type of agreement, Mr. Neal. You got a $3,000 plus interest kind of situation here. It seems to me that if there is some room to compromise on the accrued interest, that maybe you get this order entered and go forward. And I'm suggesting that maybe if the parties can discuss the prospect at this point of maybe reducing the accrued interest by maybe $1,000, maybe that will help on this. And then Mr. Wiley, you go forward and try and figure out if you want to come up with some way of paying this in lump sum, and you may be able to get reduced from the gross amount that will exist, or you could work out an arrangement to pay it on a monthly basis, and it will still be accruing interest going forward. That's the challenge. Having made some suggestions to the two of you, I'm going to ask that you take a moment and speak in a breakout room and see if you can come to a conclusion. I've tried to kind of move you in that direction and see if you can get there. And if you can, great. If not, I will set it for a hearing on that motion within the next couple of weeks or so. It's always better to try and negotiate an outcome than for the court to just have to rule on some motion and then you don't really have anything to say about it, because there's not really a debate here about whether or not there is an indebtedness. The reason that we're talking like this is because Mr. Wiley and Mr. Neal agreed that there was a debt created. So the question really is, how do you control this a little bit and figure out what you do going forward? And so I've sent you a notification for a breakout room. Go ahead and click into that and see if you can talk through it on the terms that I kind of submitted to you, something for you to think about. If that's something that's workable, see if you can work that out. If not, let's see what I need to do next in terms of trying to pull this off. Okay, so I'll be waiting your return to the Zoom room, but go ahead and take it to the breakout so you can talk back on this.
All right, thank you, Your Honor.
Mr. Jaffe, what matter are you here on, sir?
Yes, Your Honor. I'm here on Michigan Comprehensive Spine versus the City of Detroit, 21-140-786. It was scheduled for a non-jury trial today. And I just wanted to let the court know that the matter has been settled.
I do have that paperwork that has been settled. And,
Oh, okay. I didn't know if defendant had submitted it or not. I just wanted to make sure.
Thank you very much, sir.
So it's a settlement. Of course, it has to go to city council for approval, but hopefully that will happen sometime in the near future.
Very well, and I will issue a formal order with regard to this matter, indicating the parties' understanding, and the matter is conditionally dismissed, subject to automatic reinstatement if for some reason it is not approved by the governmental body.
I appreciate that, Judge. Thank you.
All right, thank you, sir. Good day to
Sure.
you. All right, this is case number 21-241239. This is Steve Davis versus Jackson Ace Management. The matter is before the court. Looks like on an appeal from the small claims division of this court. Let's see, your name for the record, sir.
Steve Anthony Davis.
All right, thank you, Mr. Davis. I'm looking for Jackson Ace Management in this regard.
They haven't showed up at either trial. This is the third one.
Thank you. So you never made a demand for the security deposit to be returned?
Yes, I made a demand after that was made the 31st when they checked the apartment out and I released the key. That was May 31st of 21. And I called continuously and she's been putting me on hold, spinning me.
Let me
So
ask you, did you put something in writing? Did you send a written document making a demand for recovery of your security deposit?
yes, there was 2 certified letters that was sent to them. And actually they sent, and there was another one as well.
And it looks like, well, you're aware that the magistrate in this matter determined that the green card receipt was signed and delivered approximately 2/26/22. Plaintiff never sent a written letter to defendant for the return of the security deposit, apparently within the time that you were supposed to do that by law. Is that in fact true that you didn't send that?
I talked to him.
You can't do it
I-
that way.
Huh?
You can't do it that way. You gotta put it in writing. You gotta make the demand, you gotta make the demand in writing, sir. That's what.
Well, if they, excuse me, if they said they spent me for 6 months about my money. They said she said she was gonna send it, and I'm waiting on, and I was patient enough. And then there was a suggestion from the secretaries that I take her to court. And that's what I did. That's when I stopped. But she wrote all my information down. Even the secretary wrote all my information down. As far as where I live, where to send the check. She even said she would send it, but she never did. So I stopped talking to him because I began to seem like I harassing them, and I just took them to court.
Yeah.
And they never showed up for court.
Well, I don't care about that part. I don't care about that part. That's not the issue. I think you know what the issue is in this matter, as I've communicated it to you a couple of times. Let me ask you, how long did you rent? You rented some property from Jackson Ace Management. Is that correct, sir?
Yes, I was
How
at.
long-
Excuse me, I'm sorry.
How long did you rent property with Jackson Ace Management, sir? How long a period?
I was in the unit for 10 years, over 10 years. They got the unit, I think in 19. And they bought it from another man. And
So let me stop you. Stop you. So you were already renting the property, and then Jackson or Jackson Ace Management took over property that you had been renting from another entity. Is that correct, sir?
yes,
All right. And you said that happened in 2019. Is that correct?
yes,
All right. Now you made your security deposit some 10 years ago. Is that true?
yes.
All right. And how much was your security deposit 10 years ago that you made?
It was 500. It stayed the same.
And when you exited the property, you did so in 2021. Is that correct, sir?
Yes,
Upon exiting the property, was there a walkthrough that was done?
Yeah.
Anything along those lines?
yes,
Sorry.
yes,
And there was an exit checklist, was it?
yes.
Did you receive any notification from the agency regarding any charges that they believe to be due?
No,
Did they send you any notification regarding your security deposit? In other words, did they send you something saying that we're keeping your security deposit because you have rent that's owed or because of damage to the property? Did you receive anything along those lines?
no, I didn't. I talked to the director, and she said that she would send a check out. And on 2 different occasions, she said that.
All right, thank you. Those verbal communications don't mean anything in real estate matters. What's written is what's important. So did you receive any written document saying that they were going to keep your money?
No,
Any checklist that they sent out saying that you will not be receiving your money because you owed some money when you left? Anything along those lines?
no,
You see anything showing that you have that you committed any damage to the property?
no.
All right, just one moment. Did you ever check with the state of Michigan regarding Jackson Ace Management as to where you might serve any lawsuit or anything on them?
No, I haven't.
Just one moment. When you were renting the property from Jackson Ace Management and the agency before that time, the address on West Chicago, is that where all the business was transacted?
That's where I took my monthly check, roughly. That's why I paid my monthly. Yes.
All right, just one moment. All right. Let me have you raise your right hand and be sworn, sir. And you are in fact Stephen Davis, is that correct, sir?
Yes.
Or is it Steve Davis or Stephen Davis?
Steve, STV.
All right, thank you, Mr. Davis. You do solemnly swear or affirm that the testimony you are about to give, the testimony that you've already given to me, that the statements that you made before the court are true, to the best of your knowledge, information, and belief, so help you God?
Yes.
All right. I asked you several questions previously regarding, you put your hand down. I asked you several questions previously regarding whether or not you have received any notification whatsoever from Jackson Ace Management, who took over the previous management company at that location. I asked you whether or not you received a letter or any notification from them stating that they were retaining the security deposit. Is that correct, sir?
Yes.
And your answer to me was that they never sent you anything in writing stating to you that they were retaining the security deposit, correct?
Correct. Yes.
And they never notified you of any damages. They never notified you in writing of any damages that they were claiming to the property that would give them a right to keep your security deposit. Is that correct, sir?
Yes.
You stated further to me that you verbally requested the security deposit and that someone in fact said that they would send it to you and never did. Is that true?
True. Yes.
And you indicated to me that the security deposit that you made approximately 10 years ago was a security deposit of $500. Is that correct? Correct, sir?
Yes.
All right. Anything else you wanted to tell me at this time, sir?
It's as I said, I talked to the director twice. Every time, other time it was her assistant, and our assistant just finally just told me I should take her to court because I guess they weren't able to do what they weren't able to do.
All right.
They just
Okay.
didn't.
All right. So someone told you that you should take them to court because apparently they weren't going to return any deposit. That's about the size of it, correct, sir?
Yes.
All right, thank you, sir. I've listened to the testimony offered in this matter. I reviewed the file. It does appear that there is sufficient service on the defendant Jackson Ace Management regarding the claim in this matter. Moreover, on testimony taken from Mr. Davis, Mr. Davis has testified, as the record would clearly reflect, that the plaintiff, strike that the defendant in this matter, the management company never gave any notification of their intent to secure or keep the security deposit in this matter as a result of any damages or obligations that may have been remaining after Mr. Davis left the property. The landowner is required by statute that to return the security deposit within 30 days of defendant's exit from the premises, so long as defendant leaves a forwarding address, and so long as there is no outstanding obligation for which the plaintiff, strike that the defendant, in this case, Jackson, may claim the right to retain the security deposit. The first step herein then is the responsibility of Jackson Ace Management, and that is that they are to give notification that they're retaining the security deposit. If they do not give a notification within 30 days that they're retaining the security deposit and the reasons upon which they are keeping it, then they have the obligation to return the security deposit. There is obviously a responsibility on Mr. Davis' part to make demand for the security deposit, but that is only triggered where the landowner seeks to retain the security deposit because of some reasons that they believe to be justified. No reasons have been given. Nothing has been put in writing to retain as a basis for retaining or keeping the security deposit. Jackson Ace has not shown up for the hearing, and the testimony of Mr. Davis is that they never sent a notice to him saying that we're keeping the security deposit because you owe rent or because you had done damage to the property. And without them giving that kind of predicate, they have no right to retain the security deposit. For that reason, the court will determine that the security deposit and the refusal to return it was improper, and that the security deposit should have been returned within the 30 days after the defendant exited the property. I moreover find that the defendant has sought return of the security deposit, providing information as to where it is to be sent, and the plaintiff has done that, and the defendant Jackson has persisted in not returning the security deposit, even suggesting to Mr. Davis that he should file a lawsuit. On that finding, then, it is the determination of the court that the security deposit was improperly retained without justification, without law. For that reason, I will award judgment on behalf of the plaintiff in this matter in the amount of $500 of the security deposit. And because there was an improper retention and the time has expired, no justification having been provided, the defendant will be entitled to triple damages. And so the amount to be returned is $1,500 plus court costs in this matter. And sir, do you remember, you recall how much you paid in court costs regarding this case, sir?
I didn't pay anything.
So you had the fees waived, is that what it was?
Yes, yeah.
All right. So $1,500, the judgment in this matter against Jackson Ace Management will be for the sum of $1,500. And I'm signing an order consistent there. We'll send a copy to you at your address on Gordon Drive in the city of Southfield.
That's Groden, Grodan.
Yeah, apartment 113, correct, sir?
Yes, yes.
All right, we'll get that out in the mail to you right away. All right, good day to
Thank
you.
you.
All right, we're back on the record. So Mr. Davis, you're free to go, sir. We're going to send that out to you, sir. All right, we're back in the record regarding the suffix 2086, Diversify versus Wiley. And thank you, Mr. Neal, Mr. Wiley, for taking a moment to go and talk about this, just to drill down on what the issues are. I see that you're close enough to trying to get this locked down. Mr. Neal, take a moment, sir.
I'm sorry, Your Honor, you broke up a little bit too, but to give a recap on the conversation we had, defendant is not willing to sign a consent judgment. So at this time, I let him know that we would be asking for a new day for the motion for summary disposition. If the court requires, I can submit a new copy, letting both the defendant and the court have a chance to review, and then whatever date the court scheduled reappear to argue that motion.
All right, sir. I really appreciate that. I know that this has been some time ago, and so I don't know why the item is not caught up to the file. But I will schedule a new date for the hearing on the motion.
That wasn't a problem, Your Honor. We had some questions, we had some words, and I was trying to figure out, because before it was, did I agree to the debt? So when I talked about the debt, I was like, well, the loan, okay, I get that. So I originally agreed to it, but I told them I also received paperwork saying that they didn't have my original paperwork from the car, for the car. And so when he was like, she paying interest on the car too, and I was like, she shouldn't be paying for the car. Her name was never on there. I got paperwork saying, and I know he has it too, that they lost my original file from the car. You know what I'm saying? That's what I was trying to get clear. I don't want to agree to nothing that I don't clearly understand. So I was trying to break it down, which we got to the bottom of that. And I was like, well, why is she paying on the car when she has nothing to do with it at all? And then when we went further into it, I was like, well, y'all lost my paperwork to the car. So y'all really needed me to agree to the car anyway within this. That was my understanding with him.
All right. Well, those are the kinds of things that motions for summary disposition resolve. And so the court will take a look at the motion and decision on the outcome of the case.
Okay.
And the date we're going to do that is going to be
Next month, June the 13th.
6/13/22 will be the hearing date. 6/13/22, 10 o'clock a.m.
Okay.
And so send that. Make sure that you get a copy to the court right away, so I can take a look at it. Get a copy to Mr. Riley, and I'll make a decision on the motion on that day.
Okay.
All right, thank you, Your Honor. We'll get that out today.
All right, thank you, gentlemen. Good day to you.